Hey, everybody, we're going to be answering some questions today about DWI. I'm Brian Foley. I'm a criminal defense lawyer and DWI attorney in Montgomery County, Texas. And it's just north of Houston. We practice in Houston, Montgomery County, and the surrounding counties. So first question, what are the immediate steps someone should take if they are arrested for a DWI? Well, if you've been arrested for a DWI, the first step is getting out of jail, because when you get arrested, they take you to the jail, but you don't stay there. Bail or bond is what they call it when you pay money to a bail bondsman in order to get you out of the jail. Typically in Montgomery County, it's going to be a $600 bond if you've never had a DWI before, there's no wreck or anything like that, and you didn't do a breath test. The reason I say that you didn't do a breath test is because it could be greater than a 0.15, and then that would mean you're not going to get an immediate bond like that. You might have bond conditions. The next immediate step in getting a DWI that you want to do, once you're bonded out, you'll want to either report to the probation department and bond conditions department if you had those conditions. So for a DWI with a 0.15 or greater, that's going to mean you have to report to the probation department, maybe get an interlock device in your car. That's a device where you blow into it in order to see if there's any alcohol in your breath, or the car won't start. The other thing that might require that is if it was a DWI second, meaning you had a prior conviction, or a DWI third or more, or a DWI with a child in the car, and then obviously intoxication assault and intoxication manslaughter. How does the legal process for a DWI case differ from other cases? Well, the first biggest distinction is that you can have your driver's license suspended in addition to having a jail or probation sentence. And we call the process for trying to avoid that suspension an ALR hearing, or administrative license revocation hearing. We will apply for those typically within 15 days of the arrest if there was a refusal or a breath test failure, or if you consented to blood, there's going to be more time to try to get something like that. Another big difference between DWI cases and other criminal cases is the minimum jail time. For a normal Class B misdemeanor, the range of punishment is 0 to 180 days in jail. For a DWI, it's between 3 days in jail and 180 days. So the idea here was that you wouldn't be able to just pay a fine and move on. However, the way that different jurisdictions handle that is they might give you credit for more than one day if you spent a single day or only a few hours in jail. So there are ways that the courts will allow you to get credit for those 3 days. What's the difference between DWI and DUI, and why does it matter in a criminal defense case? Well, in other states other than Texas, DUI might mean the same thing that DWI means. In Texas, when you have intoxication, meaning you've lost the normal use of your mental faculties or your physical faculties, or you have an alcohol concentration above 0.08, that's intoxicated. In other states, they might say that DUI means that same intoxication level. But in Texas, a DUI is a Class C offense for people who are under 21, and it does not cover somebody who's intoxicated. It would be if you're not intoxicated, but you do have a detectable amount of alcohol in your system, again, being under 21 years of age. So if you're over 21, you can't even get a DUI in Texas. It's be called DWI, or driving while intoxicated. How do breathalyzer results impact a DWI case, and can they be challenged in court? Well, a breathalyzer, or what we would call the intoxilyzer, is a company really there's a single company that makes these instruments. They were designed to have an easier way to collect some kind of evidence of intoxication. And there's a lot of different challenges that you can make to a breath test. The first ones are really about how the breath test was administered. There is a requirement for the officer to be in the continuous presence of the person who's about to be given this breath test. In Texas, it's under law 15 minutes. However, the company that actually promulgates this suggests 20 minutes. If you look at the state of Georgia, they have a manual on how to do breath testing using the same instruments, and they say it's 20 minutes. So there's a lot of discrepancies between how different states do things, and there shouldn't really be too much discrepancy in how proper science is going to be administered. They can be challenged, if you, for example, burp and you had metabolized alcohol in your stomach and you burp right before you do a breath test, that's going to artificially increase the results of your breath test. The instrument itself has to be calibrated. It needs to be within a certain tolerance. There is a reference sample, which is a known alcohol sample, or supposed to be known, and a technical supervisor will review that and create a solution of something that either is at 0.10 or 0.08, some reference that the instrument can say, okay, well, this is the known value. That's how it determines what your value is. It really compares it to this known value. And that known value is kept in a reservoir that's supposed to be at 34 degrees Celsius, and it really shouldn't change. All those different things can affect a breath test. Okay, let's take a look at the next one. What role does field sobriety testing play in a DWI case, and how can it affect the outcome? Field sobriety tests have a big role in DWI cases. The first thing that I would say you should know about field sobriety testing is there's a lot of ways that they're supposed to be done and the instructions are supposed to be administered. But what ends up happening in a DWI is jurors will look at how you did on the field sobriety test, and they'll make an assessment of whether or not they think you have lost the normal use of your mental or physical faculties just based on the video and your performance. And a lot of things can affect that. The way that the tests are administered, how the surface that you're walking on, the type of shoes you're using. Typical balance for you may not be typical for everybody. We often have clients that have things going on with their legs or their joints. They may have had reconstruction on an ankle or just the inability to walk on an ankle that has been injured in the past. And all of those different things are going to come into play because the field sobriety tests both involve walking, other than the HGN, which is an eye test. And in my experience, the eye test is the one that jurors rely on the least. Take a look at the next question. Can a person be convicted of a DWI if their blood alcohol content is under the legal limit? The answer to this is yes. In Texas, there is a definition for intoxication that includes 3 different ways that it can result. The first is the loss of normal use of mental faculties. The other is the loss of the use of physical faculties. And then the last one is having an alcohol concentration greater than 0.08. That could be breath or blood. Technically, it could also be urine in Texas, although I've never seen an officer try to collect a urine sample from somebody they'd been pulled over for DWI. What are the long-term consequences of a DWI conviction? I think the most serious part of a DWI case is the potential for that record to follow you. Canada has exclusion for people who have a conviction for DWI, but the biggest problem is if you go to apply for a job, you are a similarly situated and qualified candidate to somebody who does not have any kind of criminal history, and then there's this DWI on your record, they can use that as the deciding factor as to whether or not to allow you to have that job, to allow you to enter that lease, to allow you to rent an apartment, all sorts of things. Anytime a criminal history is run, the potential for a DWI popping up on that background check is there, and that will follow you forever. Extremely, that's the most long-term that something can be. I do think, though, as time goes on, less and less people are unfamiliar with seeing somebody with a DWI conviction. It's an extremely common crime, maybe the most common crime that's committed, because just about anybody can be in a situation where they end up getting arrested for DWI. You don't have to attempt to commit this crime to end up being arrested for it. What defenses can be used in a DWI case, and how does your firm approach defending DWI charges? So the first thing we want to look at anytime there's a DWI case, we want to look at the state's evidence, because the state has the burden of proving the case beyond a reasonable doubt. Our client has no burden to prove their innocence. And so we want to always remind a jury or a judge that that burden is on the state and it never shifts to the defense. The first way to get a case dismissed is to have no reasonable suspicion. So for example, a illegal traffic stop, like if there's the reason for pulling the vehicle over was failure to maintain a single lane, but there was nothing dangerous about the way it occurred, or the failure to maintain a lane occurred, then officers will often pull you over for that, but it doesn't meet the requirements for reasonable suspicion of a potential traffic offense there. The state has been more recently trying to get around that through reasonable suspicion of DWI, but a video that is really clear that there's no dangerousness to the failure to maintain a single lane and that there is no other indication of intoxication. Well, I think a judge is likely to suppress evidence like that, but ultimately those decisions are up to the judge or negotiations with the prosecutor. There's lots of different ways to defend a DWI later on in the process. So for example, if there's a breath or a blood test, you'll want to compare the results to something like the Dabowski chart related to physical effects of alcohol. So, for example, if the prosecutor is trying to say that their blood test is accurate and it shows that you're at a 0.210, but you are on video, you're walking and talking normally, you have maybe a few errors on a field sobriety test, but nothing that would indicate you're more than twice, almost three times the legal limit, or you are three times the legal limit. Well, if that is clearly a disconnect, then a jury may find that they don't believe the evidence of the state beyond a reasonable doubt, and you could be found not guilty in a case like that. What is the role of reasonable doubt in defending a DWI case? So, reasonable doubt is the burden of proof, the standard by which the state of Texas or the government in whatever jurisdiction you're in has to prove a criminal case. It is higher than the burden to prove a civil case, which is a preponderance of the evidence. It's like 50% plus one is any greater weight of the evidence. It's higher even than the standard to remove a child from a home. So if you sit there and think, how much evidence would you require of the state to take your child away? How much evidence would they have to produce showing that your home was dangerous? A lot of evidence, right? I've had jurors tell me 95, 97% on what clear and convincing evidence would be. All of those burdens are below the standard of beyond a reasonable doubt. Beyond a reasonable doubt is the highest standard in the law, and it requires very high levels of proof. There's no definition for it in the state of Texas. Other states have definitions. There even used to be one in the state of Texas, but now a jury gets to decide that. But the proof must be beyond a reasonable doubt. And if you just take each of those words at face value, what's another word for beyond? Maybe past or above. And then A would be, if you have a apple, you have one apple. So beyond one. And then reasonable doubt. Another word for reasonable might be a normal or reliable or some other word like that. And then a doubt would be maybe a question. It's beyond a reasonable doubt. It's past a single normal question that you would have. If you have an issue with the case and you're back there in the jury room, then you may have a reasonable doubt. And then the Constitution and the laws of the United States require you to find somebody not guilty if you have any reasonable doubt about the case. So what happens if someone refuses to take a breath or a blood test after DWI arrest? In Texas, you can have your driver's license suspended, not for just testing positive or testing over the limit for alcohol, but you could have it suspended just for refusing to take a breath or blood test. It's called the implied consent law. And in Texas, the Department of Public Safety, if you refuse a DWI test, may suspend your license for up to 180 days. And what we do at my firm is we will contest those suspensions either at an ALR hearing, where we can subpoena the police officer and challenge the reason for the stop, whether there was probable cause for the arrest or the result of a breath test. And then in addition to that, we will also request an occupational driver's license. If for some reason we lose that hearing, we'll continue to get the ability to drive, even with the suspension, by getting what's called that occupational license. It allows you to drive to work, to church, to get groceries, things like that. I always say you just can't drive yourself to the movies. If you're going somewhere for fun, you need to get somebody else to drive you if you have an occupational license. Okay, that was all our DWI questions for today. We will see you next time. I appreciate you guys watching. If you like what you saw, don't forget to like and subscribe. Thanks so much.